Mimi, I'm very honoured and privileged to introduce as she works with me at Matthews Folbig Lawyers. Mimi is one of our specialists in estate planning. She works on deceased estate matters and also tax-related issues. She has extensive experience in all aspects of estate planning, including preparing testamentary trust wills and advising on various asset structures such as family trusts, special disability trusts and superannuation funds. She's acted for a wide range of individuals, including notable high net worth individuals and family groups in respect to obtaining grants of probate, dealing with concerned estate matters and capacity issues. It's her background in taxation from a Big Four accounting firm and having completed her Master of Laws specialising in taxation that means that she can provide tax-conscious legal advice, which is becoming increasingly a necessity given the complexity of family group structures and asset holdings. Mimi is going to be looking specifically at how the process of thinking through and then developing a will helps to flesh out some of those issues that Gary has just raised. Over to you, Mimi.
Thanks, Jeff, for that great introduction. So my name is Mimi Sue. I'm a solicitor that works at Matthews Folbig Lawyers. I specialise in wills and estate planning. So following on from Gary's presentation, so what does wills and estate planning have to do with if you're a member of the free-range families or the silver liners group? Well, first of all, from Gary's presentation, we know that if you're a person that fits within the free-range families category, you're somebody that's happy, you're happy with your family, you have a good relationship with your family during your lifetime. So it makes sense that when you pass away, you should have a will that you should hope would ensure harmony between your family members. What we're trying to do in the estate planning world is to minimise any friction or disputes that could arise. Similarly, with the same line of thought, with silver liner families, what's important to them is planning for the future and making sure that their families are as wherever possible as financially secure as possible. So once again, this leads into my presentation as to why it's important to have a will, and that is obviously the starting point. You've seen from the earlier statistics that more than half of the Australian population don't have wills. So the starting point is to have a will, because the will is important in terms of documenting the will maker's intentions as to what they would like to do with their estate and how they would like their assets to be distributed. It is becoming increasingly more important now in society to have a will, because families generally are becoming wealthier. And for the people that fall within either a free-range family or you're a silver liner, you heard that they generally hold property. So as a starting point, you have a property, you should have a will. Because of the fact that estates are bigger, there are now more disputes arising in this area, because if there's more assets around, it's more worthwhile to have a dispute sometimes. Families are also more complicated now. The nuclear family, where you have a mum and dad and 2 kids, and that's the first marriage for those 2 people. There's not children floating around from other relationships, is no longer the norm. So when you have it's more of a blended family context. It's not that nucleus family. It's more the opportunities for disputes to arise following your death is on the rise. So in my line of work, when we talk about wills and estate planning, what we're trying to achieve for our clients is constructing an estate plan or a will which for them will minimise any potential for disputes down the track when they pass away. So with the drafting of a will, we like to, wherever possible, keep things simple and as straightforward as possible, because there is a lot of beauty in being able to keep things simple. As a starting point, though, even something as simple as who you would like to choose as executor, although it's a simple concept, can cause friction within the family members. So, for instance, if you have 2 kids, a lot of people will come in to see me and say, my preference is to have only one of the children because the two of them don't get along, or I could see that the brother would be exerting a lot of control or influence over the sister. So just this is a starting point, having that important discussion about who should be the executive of the will is an important consideration. And following on from that, your will only takes effect when you've passed away. Other documents that you should think about as part of the estate planning process is a document called a power of attorney, which determines who you would like to nominate somebody during your lifetime to make financial decisions for you if you become incapable. And obviously there's a bit of thought process that goes into who's the best person in your family for you to nominate as your attorney. And once again, when we look at it holistically, we're talking about, when we have these conversations with clients, where our starting point is to say who is the best pick for you, and also to try to minimise any disputes or friction that could occur between your children because of the choices that you've made. The second point about that is that we do like to try to keep the will as simple as possible. So for instance, wherever possible, we look at everything in your estate and we call it the residue, and we say it's equally between the kids, or we figure out a percentage split between those residue assets, as opposed to having specific gifting of properties or shares or cash. And that just assists with down the track when you've passed away and we need to administer your estate. And if you've sold or bought new shares, different houses, it takes away some of those complications that can arise. So from a advice perspective, we always try to not recommend specific gifting, but that's, once again, the solution for that really needs to be tailored to the needs of the client. And obviously that's why it is important to seek specialist advice in this area. The third point, though, I'll finish with in this, what are the starting things to consider when you're doing a will is, common question that comes up is a discussion around should I have equal distribution or unequal distribution, more in the context of children. Naturally, for a lot of people, if you've got 2 kids, it goes without saying it should be an equal distribution between those 2 kids. If it's 3 kids, it's equal distribution between those 3 kids. That, a lot of the times, is usually not controversial and doesn't cause problems down the track between your children should you pass away. Equally, on the other flip side of that, though, there is some very good reasons why a discussion sometimes is had between the parents or the will makers as to why there should be unequal distribution between the kids. Because, for instance, maybe if there's 2 children, one of them is actually particularly wealthy in their own right, and maybe the other sibling actually is not wealthy and could also suffer from a disability. So that those types of family contexts, it's just important to have the conversation with us as the professional advisor as to what they feel is the objectives of what they want to achieve with their children. And we also encourage, wherever possible, to bring the children in on the conversation early, because with families, obviously, as you know, if you're happy with your family, you all get along now, the will that you want to leave following your death is one in which you want to minimise any disruption to that harmonious family. So it's important, wherever possible, to bring them into that conversation. Whether it's equal distribution or unequal distribution, there's really no right or wrong answer to that. It really does depend on the family circumstances and the relationships that you have with those children and the children between themselves as well. So just following on from that, I then move on to some of the things that in the world of estate planning wills that can get a bit more complicated. What we aim to do is always to try to achieve the best will for your beneficiaries, which is each will look different, because obviously it would depend on what your beneficiaries look like. I've categorised different types of beneficiaries. So the first one there I've referred to is a vulnerable beneficiary. And by this I mean you could have a person that you want to inherit from your estate, be it a child who either is a bit of a spendthrift, or potentially they're easily influenced by people that you think are a bad influence on them, or they might have a disability, so it should be the case that they would never be in a position to manage their own finances or the inheritance that you would leave them. So in those circumstances, we would have a discussion with you as to what's the best type of structure and how you should leave your estate or give the inheritance to that person who's vulnerable. The second category of a beneficiary is that they could actually be reluctant. In this context, I'm referring to people who, for instance, now with an ageing population, a lot of people live well into their 90s. That's not unusual now. They live well into their 90s, so by the time they actually pass away, their children would be maybe in the 60 plus category. They might actually, the child who's in the 60 plus category might actually be on the full aged pension, or they could be on a partial pension. And the context that I've seen, but in instances when they've come to see me, it's already too late. When the parent has passed away, the one that's in the 90s, and the child's about to receive the inheritance under the will, they actually tell me they don't want it because as a result of receiving the inheritance, it pushes them over the Centrelink asset test limits. So as a result, they're a real reluctant beneficiary. But once they've been left that gift under the will, even if they say they don't want it, you can't get around the Centrelink asset rules. So with that, it's really, once again, for the will maker or the parent to have the conversation with the advisor in this area, consider what the circumstances of the children in their family is, and try to craft a will that would best suit your family circumstances. The third type of, the point there I talk about is that if the beneficiary has a disability or there's other issues as well, maybe the beneficiary shouldn't be the child directly, or it shouldn't be that person directly. The estate or part of the estate should actually be left to a trust as the beneficiary. There are some merits in pursuing that type of will. For instance, if the estate is quite a sizable amount, then for tax planning opportunities, there are instances where it would make more sense to place the estate assets into a trust as opposed to directly to a beneficiary. I'll just then move on to circumstances where there's been complications that arise in the estate that are quite difficult to deal with. As much as, it sounds wonderful if you fulfill the statistics of being a free-range family or a silver liner. We know that that's only 7% of the population in either. So there's lots of other families out there that are not happy, or are not, they don't have great relationships with their kids, or they don't talk to their kids. There are instances where we're dealing with a client where they do have an estrangement with a child or children. So what do they do about that in the context of a will? They come in to see us, and the will maker might have very clear intentions as to they want to exclude that specific child because of past behaviour or the sheer lack of contact over decades. So it's important that we have that conversation with them and then provide advice around that, because certainly they are within their legal rights to do the will as they want, because that's the freedom that a will maker has. But there are also, on the flip side of that, implications down the track when the person does pass away and the will ends up being contested. So all this kind of stuff is all very general that I'm talking to you about, because with each family and each individual, it's very much dependent on their circumstances, what type of specialist advice we can provide to them to deal with these different type of scenarios. The second example I've got there of what can lead to more complications in the estate planning world is I'm talking about blended families. So this is not to say that blended families are not happy families. Lots of blended families are happy, but I'm talking about by blended families, I mean families where either the husband and the wife or the couple have previously been married and they have adult children from that first relationship. They've now married. It's a second relationship. They might not have children together. In some instances, they have younger children together. So these are the types of families that I'm talking about when I refer to blended families. Now, it's not to say that they're not happy. It's just that because when there are more people involved in your family and your extended family, there's more people that on your passing, will have conflicting interests as to, they think they should have gotten this and, and somebody else shouldn't have gotten as much as, as the other person. So that's, and in these types of scenarios, sometimes it's, if you're fortunate enough where you're in an estate where there's just lots of assets, it's not as big of a problem because then there is the potential where there's plenty to go around, so to speak. There's enough there to cater for the adult children from the prior relationship, whilst not taking away too much from your surviving spouse who might have, young minor children to also cater for. So there's in those circumstances, it's easier to advise clients on because there's, enough assets there to go around, although some people might not think that that's enough. But in any, moving on from that, if generally, when it gets hard though is when the estate is smaller and the will maker does actually have to pick in terms of, pick and prioritise. And generally what I would see in this context is that the priority would be to your surviving spouse, so the spouse that you're currently in the relationship with. And obviously if there's younger children as a result of the second relationship or the second marriage, they tend to be the priority. And then you might, this is an area where a lot of the litigation is arising, where it's the stepmother or the spouse from the second relationship on one side who's the main beneficiary under a will, and the adult children from the prior relationship. This is an area which is being really geared up for, and it's fruitful for litigation, as you can see why in this context. From our point of view, it's really about the client coming in. They have to really lay it all out there in terms of disclosing the circumstances, and we try to work through it in terms of how to best cater for everybody's interest as much as possible to try to minimise the opportunities that a claim would be made following your death. The third element that I've raised there in the slides that also does complicate wills and estate planning is if a lot of the wealth is actually tied up in a family business. It's not actually personally held, so it could be in a trust structure, it could be a company, and that's actually, they're the entities that you actually run your family business through. It gets even more complicated if you have, say you have two children and only one of them, say the son is the one that's actually been helping you with the business, works in the business, and the daughter or the other child doesn't work in the business. And most people, I would say, come in and say, if I've got two children, I want to treat them equally, with the view in mind that they want my disputes down the track. But then in other instances I've seen, the parents will come in and say they actually want to reward the son because he's the one that has been working in the business and he should be somewhat compensated as a result of that. So there's no right or wrong in terms of when a person comes in to see you and they point out clearly to you, these are my objectives and this is how I feel. Our job is really to navigate that through them and tell them possible strategies of how this can be done in order to minimise disputes down the track. And it would go back to my point again, if possible, to bring the children in on the conversation and the discussion early as part of the estate planning process, because it just, if nothing else, it minimises the chance that when somebody's passed away and there's been a shock at the will reading, or somebody's really disgruntled because they other than the grief of one of the parents passing away, they've then, they've met with this will that this is not what they expected, or they were thought that they were going to get more. So being able to take away some of that, it almost, even if it's not what they would have liked, it softens the impact, is what I'm trying to say, if they could have been brought in earlier to the conversation. And I understand that sometimes that's not always possible because of the family dynamics. So that's what I'll end on on that topic. But you'll see though, for on one of my last slides, that doing a will and is not. I mean, we like to start off by making it as simple as possible because there's real merits in that. It's understandable for the will maker and it's understandable for the beneficiaries that are going through it and reading it. But like I said to you, people's circumstances and their families and also the wealth that people have now has, exponentially increased over the last few decades. So this area is very fruitful for disputes that occur. And whilst our job is to try to minimise that as much as possible, it's really a matter of taking the first step to see a lawyer about it. You really need to lay all your, all the skeletons in the closet generally have to come out in the first meeting. They tell me all, and then our job is basically to craft the best estate plan for their specific children or beneficiaries that they're trying to cater for, whilst also giving them advice about the problems that can avoid. Now, we've all seen it. I've just pointed out some recent cases of deceased famous people where their estate or their will has been litigated because not everybody in the family or the extended family is happy about it. They're just obviously some of the cases. There's, it's just I didn't need to put those two names up there, but any day, any week now on the Sydney Morning Herald or news.com, there's various cases or stories about people's wills being disputed. So, as you know, the first one I've got up there is about Bart Cummings, the famous horse trainer. He passed away. Not everybody in his family was happy with the contents of his will. Similarly with Bob Hawke as well, and that's a perfect example of a blended family. Blanche, his second wife, inherited most of the estate, and there was a dispute that arose from an adult daughter from Bob's first marriage who contested the will on the basis that she got left $750,000 and she felt that wasn't enough. So the laws, whilst a will maker can do a will and it's very clear in the will what their intentions are, there's a whole other flip side of it where there are people potentially that can make a claim against your estate on the basis that they've been inadequately provided for. So our job as professional advisors is really, once again, is about try to get you into the door early, have a conversation early with you about what your objectives are, and to try to maintain, wherever possible, harmony within your family following your passing away, because at the end of the day, it makes sense. If you're happy during your life, you have good relationships with your children or your other extended family during your lifetime, it's important that for you, I would think, that as a legacy that you leave your family is also a happy one. And that concludes my end of the presentation.
Well, that's great. Thank you very much, Mimi. Certainly in my experience as a solicitor, and certainly in yours as well, many clients come to us with a view that their particular problems are so extreme or unique that it is difficult for us to be able to fashion a solution for them. But that's where it's really important to get advice from experienced legal practitioners. There's a very good chance that we have seen a similar situation before, and it's also nearly always the case that there are existing legal principles or certainly documents that can be called upon that will alleviate those problems. But the other thing we pride ourselves on is reducing this down to its most basic element, which is relationships between human beings. We like to say that the earlier you can come in, as you've just said, Mimi, the more likely it is that we will be able to fashion a solution that, very importantly, ensures a trouble-free, I should say, transition through that probate period, so that beneficiaries know what is on the horizon. The legal problems, and there are always legal problems, are ironed out before the only solution is litigation, which is obviously a bad result for everyone.